Right. So
And I just wanted to correct something that you said. We're not just talking about razors and scooters. We're talking about 320 different products that one study found, and we could send you the list of what those products are. So you could see that some of them are essential products that people depend on. It's not just a convenience product. It's something that they depend on for their personal care and hygiene and health, like vitamins, for example.
Any other? Ms. Garcia?
I agree there is a problem, actually, and there is gender pricing that's happening out there, and the studies mentioned here and more recent ones continue to confirm what we've been seeing for a decade. So I think it's unfair to say that that's not a reality, and so I think that really is happening. And I think, and I appreciate the attention you're bringing to this issue. It creates a platform and an opportunity to educate along the way and have a discussion. That's very important, so thank you for that. Like yourself, I grew up in the poor part of town, had limited places to go to. I still live in that poor part of town, except that now I do have a car and I can drive myself out of that poor part of town to other places where there are more stores. And so I am an exception in my community because I have that option. Like yourself, had that mother that struggled with being on welfare with 5 kids, single parent at that point. So I think, and I continue to live there, these things happen, and we need to describe this. I do not feel that the proposed legislation gets at where we need to, and I have some questions, and I'll explain that further also. And just because we have a problem pushing forward a bill that I feel is not good policy, also goes against not just, I can't just be a woman, but I have to be a legislator, and I'm trying to think about those. This is going straight to the floor. And so I don't feel comfortable moving this bill forward. And I'm speaking for myself here. When the committee does, it's up to them. I'm going to start with the list of questions. So the first one is, the new car dealers just removed their opposition. Are we giving a carve-out to the car dealers, and can we explain if we are and why?
No, not at all. And that was my condition, that we don't water down the UNRU Act. They felt that because an automobile is a negotiated item, it's an item that has a price on the windshield that's clearly marked, and if you want to negotiate that price down, they're willing to do that. And that raises some concerns about people's negotiating skills, or whether they even choose to negotiate, or whether some dealers will even negotiate at all. And I thought it was fair based on just that one distinction that I just felt it was fair that based on that distinction that the amendment we agreed to was a fairly watered down amendment that again created some additional definitions related to negotiated items.
Even though we've seen, irrespective of my negotiation skills or not, that the gender issue is a real issue when you go in to buy a car dealer, and
it is
where they're willing to come down from that.
That's why I refuse to add any amendments that would water down the UNRU Act, and that's something to their credit. I'm glad that.
On page 3.
I'm glad that they were willing to accept an amendment that clearly upheld the strength of the UNRU Act. In addition to that, we did add language that states that their exemption shall not impact or prohibit an UNRU lawsuit.
But in page 3, it says that goods shall not include any food as defined by Section 12502 of the Food and Agricultural Code, or goods sold by new motor vehicle dealers as defined by Section 426 of the Vehicle Code. So we've given an exemption to cars.
An exemption does not exist.
Am I reading this wrong?
What's that?
Am I reading page 3 wrong?
In its application, yeah, and just in the context you're reading it, yes, it's wrong.
Even though it says that it shall not include. Okay.
But what you've done is you've removed new motor vehicles from the definition of goods that are being addressed here, so that is an exclusion.
Page 3, line 3.
But we also have some additional language that states that their exemptions shall not impact or prohibit an UNRU lawsuit against them should they violate the civil rights, the UNRU Act. Again, that was specifically added for negotiated products.
So the amendment that you're talking about is for other UNRU lawsuits or issues, but there is an exemption specifically for gender pricing in here for cars, according to the language on page 3, starting in line 3.
Do you have a problem with that language?
I do.
Would you like to amend it?
No, well, I wouldn't. I mean, we start to give these carve-outs to a car, including the analysis. We talk about how cars is an example of where we have gender pricing issues.
If you have a problem with it, I'll work with you to amend that.
So you're going to get rid of the exemption for the cars in here.
If you have a problem with that, I'll work with you on that.
Okay. Even if you do that, my opposition continues. So let me go on to my next part. We talked a lot about marketing in here in the discussion from both the opponents and the proponent sides on marketing. So the bill is looking at what the retailers are doing, and you gave some language that said if the price was set by the manufacturer, then the retailer is not subject. But then we continue to possibly have gender pricing issues from the manufacturing level or how we're marketing to individuals. The reality is that we have a problem that I think goes much deeper than just the retailers and their practices. And we have, whether we get rid of male and female sections, definitely a worthy idea to explore out there. It might be, whether it's a solution or not, I think. But we're putting the onus on the retailers here when I think the problem we have here is much bigger, and I think if we're going to address that, we need to go wider.
If I can correct you there, we're not, because when it's a function of the manufacturer, the onus is not on the retailer. The onus becomes placed on the manufacturer. So if a consumer finds that there's a discrimination going on, but the origin is the manufacturer who's discriminating, the consumer can go after the manufacturer, not the retailer. And that was something that the retail industry asked for, and that's something that we worked with them on. I don't necessarily think it's necessary, but I'll agree to it because it doesn't water down the UNRU Act, and it just creates a clarification. If they're not responsible, that can be used to hold them, harmless. And I'm okay with that. I'm not after retailers getting sued. I don't want that. I don't want frivolous lawsuits. If it is a manufacturer, they should be directed there, and the manufacturer should be challenged.
I have a manufacturer here, someone that wants to speak, or retailers that want to speak to that.
I'm Margaret Glasgow on behalf of the California Retailers Association. I just wanted to be clear. We raised a variety of issues with the author's office as to why we have a variety of prices, but we did not specifically seek that amendment.
Okay. So if I'm a consumer, because I start at the retailer, and so I say I'm going to sue the retailer defends themselves and say it's the manufacturer. So now I have to go to the manufacturer for this. Or who do I sue for the marketing also issue that we have out there? I just want to know kind of the steps I need to go through to get to address the problem. How many steps do I, as a consumer, need to go to possibly, and how many potential lawsuits do I need to start to get to the end?
Under this bill, you have a pathway, and honestly, it's not a funny issue.
I don't think it's a funny issue either.
It's a serious matter.
I'm not laughing at the issue. I have some issues with the policy.
And putting in a provision that holds somebody harmless when they're not responsible, I think is fair. But it also gives people recourse, give them a pathway to achieve justice, which is what this bill does. Now they can go after the manufacturer should they find that the manufacturer is responsible. The retailer will have an opportunity in the court of law to demonstrate that they are not responsible for the pricing that they are charging. I think that's fair. If you do not, tell me what you think is fair.
I will say, please refrain. I did not. If you saw a smirk on my face, it was not of the issue. I am very much, and I started off by saying very much in agreement that we have a problem here, and very much appreciative of the attention we're putting on this problem. Very much in disagreement with the policy in front of us. At this point, I don't have a solution for you. I think a working group to figure out how we get there would be important. It's something that I'm very much committed to work with you in the future. At this point, my capacity is limited, and so I find it difficult to be on the opposite side of groups that I normally work with, California Now, Planned Parenthood, on issues that I'm very passionate about. But I can't just vote for this because I'm a woman and I agree we have a problem. I want to see some better policy, and I'd like to see a working group to try to get there, to create something. And we're probably not going to remove all the opposition along the way. That's a reality that's out there. But I do think we could have a better way to approach this problem. Right now, I feel you're putting too much responsibility on the retailer.
Mr. Alejo.
Well, first of all, nothing precludes a working group from taking place, even if this bill moves forward and is signed into law. That should be. Obviously, when you look at the evidence and studies that were done decades ago, and they relook at those studies and you find out that not much has changed, for me, it demonstrates there's an ongoing problem. And every civil rights law, almost go to every one, it doesn't resolve every situation, every type of scenario. Civil rights laws have evolved. The Civil Rights Act of 1964 covered various aspects of discrimination, but we still needed the Voting Rights Act of 1965 and many laws since then. If you look at the origins of the UNRU Civil Rights Act, it didn't include every category. Just a few years ago, they included primary language, citizenship, and immigration status to be covered under the Civil Rights Act. So every civil rights law doesn't cover every single scenario, but nonetheless, they evolve and it tries to address many types of discrimination. But as the law evolves and situations arise, then there's additional follow-up legislation that tries to include and address those situations. And we're not just talking about goods here. According to analysis in the bill, it also addresses services. And when you see that people come in and bring a comparable shirt and they charge more at the dry cleaners or for other types of services, it troubles you that to this day, at the end of the year, a woman would pay thousands of dollars or more overall in terms of all the products and services that are consumed in a year than a male. And as Senator Wessel correctly pointed out, like any civil rights statutes, they're provided an opportunity to go in court, and if there's gender-neutral reasons why the price was different, well, that's an opportunity to prove that in court. But if they're able to prove that there was no other reason other than gender for the price differentiation on a comparable product, that will also be given its day in court and be able to see if there is liability under this statute. I commend the author and the principal author for bringing this bill forward, but for me, it's kind of a sad thing that after decades of seeing what has happened, not only in California but in other states, that you still see comparable products that are being priced differently, and you see the disparate impact that it has on our communities. That we can't just have a hearing and say, well, it doesn't address every situation, it doesn't cover every scenario. We know there's an ongoing problem. This bill is trying to address a lot of aspects of that, and it's worthy of moving forward today, and that's why I moved this bill, and I'll support it today.
Mr. Holden.
Thank you, Mr. Chair. I think the bill has all the merit that has been talked about today in terms of what it represents. There is a question that kind of came up in the previous conversation regarding substantially similar or like kind, and the suggestion that there wasn't enough guidance in the bill to define what that represents. I guess for me, I want to be comfortable too with that which we approve and goes forward, that there's ability for it to work in its application as opposed to the fallback being the safety net of lawsuit, that, well, if we can't figure it out, there's a lawsuit, that at least there's a way for the bill to be clearly defined so that that piece that you're trying to implement, if you are the retailer, that you're not sort of caught in a situation where, or the customer, where the conflict, if there becomes one, the only solution is litigation. So I guess I would want to maybe also hear from the retailers or those who are imposed who make that as their main argument, and to see if there's something that can be offered that addresses or gives that kind of guidance. And I know there's been a lot of conversation. I know that you've worked on this, but I'd like to at least hear a little bit more why that's been a concern or is continuing to be a concern from those who are opposed.
Did you have a question for?
Yeah, if I can
and-
just,
and-
yes,
and-
I'd like to
offered-
respond to that, because
Okay.
let me give you an
And
example.
I think, and the chamber, that was a question really for
both.
the chamber and for both. So let's.
We're essentially creating a rule saying you can't discriminate on the sale of goods based on gender. Just like we would create a rule saying you can't discriminate based on ethnicity when you hire somebody, you can't discriminate based on gender when you pay them. We have, let me give you a rule related to food. We have a rule saying that if you sell 100% bee honey, it's got to be 100% bee honey. Yet we have people adding high fructose corn syrup to that. And who is actually regulating that and ensuring that that is being done? It's actually regulated by the marketplace. You have people, beekeepers or bee sellers, that go and test every product to make sure it is 100%. If they don't, they sue the manufacturer and they bring them into compliance. That's our system of government. That's the way our society works. We don't have enough government to have enough people to regulate every single code. So we leave it up to consumers and consumer groups to take it upon themselves to test those products and to bring a challenge if that is the case. Same with hiring people based on ethnicity. If there's a discrimination, you hire somebody wrongly, that person brings a lawsuit. And the question is, though, does the issue of gender rise to the level of importance as ethnicity, religion, as anything else that we create a rule for? Does the issue of gender rise to that level? They're going to claim, oh, this is going to lead to proliferation of lawsuits. Is there a proliferation of lawsuits on all those areas that I mentioned? Not really. We had one of the members claim that there was a proliferation of lawsuits. We asked for that information. They couldn't provide it. We've asked the industry to provide that for information. They couldn't provide it. We asked the committee to provide that information. They couldn't provide it. So, yeah, you're going to hear, the claims of the industry saying there's going to be proliferation of frivolous lawsuits. But there will also be a potentially proliferation of lawsuits that have merit. And I brought up the example of the ADA, Americans with Disability Act. Yeah, a lot of businesses have paid a lot of money and they've been inconvenienced. I agree. But they were businesses that were out of compliance. And when that law was signed into place by President Bush.
The question was specific to the definition of substantially similar. And
yes.
I think if we could come back to that and answer that question, and maybe have the chamber answer that question.
Sure. Thank you so much, Mr. Chair and Mr. Assemblymember Holden, for the question. Look, we are very concerned with the litigation aspect because we have seen already evidence of the existence of such litigation. Right now, if there is a difference in price of only a penny, of 10 cents, of 50 cents, it is a minimum $4,000 statutory damages, regardless of whether you are actually harmed or what your actual damages are. And unlike other existing situations, such as a wrongful termination, where we actually have a department dedicated to investigating and representing employees in the situation, there's no such existing agency for the Unruh Civil Rights Act. I can have Mr. Pani Agua, if I hope I did that right, come up and testify that he has gone to various agencies for him and the other 10 businesses who have been sued under the existing Gender Tax Services Tax Repeal Act to try and get some assistance to help them defend themselves against these lawsuits brought by one attorney and his girlfriend, who have filed 2 lawsuits a week for the last 2 months against small businesses alleging that they were discriminated against with the services applied, despite the fact that those business owners told him up front, told the attorney and his girlfriend, that you are being charged a different price because of the cost and the expense of labor that goes into cutting a woman's hair that is longer than a men's haircut, that is going into drying a silk blouse, dry cleaning a silk blouse, opposed to a men's shirt that is a cotton shirt. That is a 50-cent difference. They are being sued for $60,000 to $80,000 for a $4 difference in a haircut, for a 50-cent difference in the dry cleaning. He has the lawsuits available for you to review. He has the complaints. So to suggest that it's not going to happen is not respecting the fact that he's undergoing litigation right now and has reached out to agencies to assist him. Look, I do not think that we need to have a lawsuit of a minimum $4,000 statutory damages, especially when the business owner has told them up front the justification for the difference in price, and now they have to go and spend the cost of defense. A small business owner has to go to litigation to prove that they were justified in charging that distinction in price. Again, we are not suggesting that there should be gender discrimination. We do not believe a woman should be charged a different price than a man for the exact same product. This is dealing with substantially similar. It's an ambiguous definition. It's an ambiguous issue, and it's a minimum $4,000, which will leverage these small businesses into deciding, do I pay for the cost of defense to go and defend myself, or do I settle out?
It's ambiguous until we define it. Now, let me tell you the definition.
But can I ask on that point, though?
Yeah.
I guess what I'm really getting at is, I've heard all of this now, and so what guidance, what benchmarks, what is a quantifiable way of sort of, in your mind, giving clarity to the marketplace that, okay, if I cross that line, then there I am. I'm in a place where I've violated.
Senator, could you wait? He's asking a question of the witness. Would you just let him do that, please?
Yeah, and I just wanted
Thank you.
to
Hold off, please.
Okay.
Let me just
Before she answers, I just want to provide a context.
Okay.
That's all.
Senator, could you let the witness answer, please? Thank you.
So what guidance? We've talked with Assemblymember Garcia about this issue with regards to the women's issue. We've talked with the senator when this bill was first introduced that we do fear the type of ADA litigation that has happened, and I agree with him wholeheartedly that a lot of the ADA cases have merit. And when we've engaged in discussions, repeated discussions with committee members and consultants on this committee to try and address the frivolous lawsuits, we have tried to distinguish between those that have merit and those that do not. But there is no denying that there has been years of frivolous litigation filed against small business owners that has been costly. And what came of that last year, or this year, excuse me, there was a bill by Senator Roth to introduce a notice and right to cure for these so that these small business owners are not subjected to the minimum $4,000 damages, that they're not forced to go to litigation and defend themselves when the issue is something that can be cured, resolved in 10 days, 15 days, that can be resolved in 120 days. We have difference in prices of 50 cents and $4 that are being sued for $60,000 to $80,000, $100,000, and jeopardizing the businesses of these small business owners. So we've already raised that issue with the senator's office back when this bill was pending in the Senate. This is something that we are very concerned with because we've already seen examples of it happening, and we don't want to see the same repeat issue go on with regards to this issue as well.
Can I provide the context now? The bill defines substantially similar or like kind if they do all of the following. They share the same brand, they share the same functional components, and they share 90% of the same materials or ingredients. Now that provides some guidance. If you want to add more, I'm up to definitions that don't. Again, my standard is not watering down the UNRU Act. I think we've held true to that in the amendments of this bill. But generally speaking, we're talking about, she mentions $40 or $90 or $100,000 lawsuits on a product that's worth, a few pennies or a few dollars. But we're talking about millions of dollars here, hundreds of millions of dollars that translates to. This is an industry. Just that one section of overcharging women for similar goods is $100 million, multiple $1 million industry. So this is not a minor issue. That's why the opposition is so tough here. They're coming up against this issue with everything they've got, and I understand that. But I mean, I'm willing to work. I mean, bottom line, there shouldn't be discrimination in the sale of goods. We've been trying to respond to every argument in the drafting of this bill. It's gone through various modifications. We thought it was fine to begin with, but we're working with the industry. We'll work with you to address some of the concerns you have. But in no other area of law do we have to define things as clearly. You understand that ethnicity is never very clear what ethnicity is. We don't have to define that in law like we're defining this. And that's where it's just, going to additional steps to try to kill this bill. The issue is, should we discriminate based on gender in the marketplace? Bottom line, and that's what we want to pass. We want to work with you to do that.
We understand that. That's been reiterated. Does that answer your question, Mr. Holden?
Well, I think I don't think it got me any place closer to where I need to be in terms of having the kind of clarity. I think that the senator did sort of identify guidelines that are broader, that are in the bill, that I was looking for something that would say, okay, as opposition, we need to see it sort of clearly defined in a certain way that will make it clear to the marketplace as this bill goes forward. And I guess that's what I'm looking to compare against what the senator said in identifying 3 areas that there is guidance in, maybe broad, but nonetheless guidelines. And so that's where I guess I was trying to get at. I mean, hearing the philosophical arguments, which the fundamental argument I agree with in terms of the author's position. But as we drill down on this, and I've heard your argument from what happens when this gets out there and what does this mean, and that's why I pose the question, okay, well, I don't necessarily want to see it every case defined by a lawsuit sort of in a court for figuring it out. So if there is a clearer, more defined, more specific way of having this bill establish a benchmark, because I yield on wanting to see, buying the argument and wanting to see it continue to move forward, but also, as my colleague has pointed out, there are some applications out there that if we can figure it out now, I'd like to figure it out. And but again, I don't have the answers at this particular moment. So I'm highlighting a concern, and I'm responding to a point that you raised that I think has merit. But I'm also measuring how I feel against what the author's intent is here, and that I completely align with. So I need some guidance, I guess, is what I'm really saying.
Is that a question?
Are you asking a question?
I guess my original question, the senator gave some guidelines that are in the bill. They're broad. The opponents have said that the guideline, that there's nothing that's very clear enough, and I guess I'm trying to find out what is a clearer guideline from their point of view that would help make it easier for me to support the bill.
So is there a clearer guideline?
Is there a clearer guideline on what substantially similar is?
Yes.
I mean, look, if we sat down and tried to hash out for all products in the economy as to what substantially similar means, I don't know if we can get there. I don't know, and I'm not sure that we can. But right now I can tell you that the definition is a challenge. Look, what if there's a 1%, one product in there, one ingredient in that product that changes the cost of that product, right? And it's a gender-neutral reason, and that is the reason that one is priced 20 cents, 50 cents higher than the other product that looks substantially similar.
So, we're getting lots of repetition here. The answer is no.
Yeah, no, I don't know. I don't know if there is or not, quite honestly. But I can tell you that we're now in the last policy committee before this goes to the assembly floor, and these questions are still being raised as to whether or not the definition of substantially similar is confined enough to prevent the frivolous litigation as to whether a notice and right to cure should be included in the bill like we did with ADA litigation.
I'm trying to find out if there was an opportunity to sort of bridge the gap before, because if it falls on me to kill a bill like this in this committee, I'm probably not going to do that. But is there a concern about that you've raised that I think is a valid concern? I think there is. And so, the author still seems willing to sort of sit down and figure it out. I don't know if that creates enough time. And then I guess I could just say, well, if it doesn't go far enough and it comes to the floor, then maybe I have a reserve the right that you make your argument and it hasn't been addressed, and I have even more time to take a
Once
deeper
out of
look
this
at
committee, there's the recommendation.
It goes to the
motion.
floor.
We do have a motion. We don't have a second yet, but we do have a motion. And once it goes out of this committee, it goes to the floor.
Correct.
So there's really not, to the question before each of us on this committee is this bill in form enough to move? And we can vote yes,
Well,
we can vote no.
I guess what I'm saying is you don't believe it can be amended on the floor?
It can be amended on the floor.
Well, that's the point I'm making.
Yeah.
I mean, if it look,
Yeah.
I don't want to belabor this. I mean, you've indicated that it's a very right today in this moment, given the magnitudes of the issues that you understand them to be in terms of retailers and the manufacturing community, that it would be hard to come up with a cleaner way of having guidelines that would be easier for folks to follow. But if you say, hey, I think we can get there, I think that there is more that we can talk about, we think that there is an opportunity to sort of put our minds together and sort of identify some clearer or better benchmarks than that which the bill currently has in it, then that would be encouraging.
Assemblymember, the only thing I can't speculate, honestly. I wish I could have a magic ball in front of me and say that we will be able to fix this. But I can say that our letter hasn't changed since day one when this was introduced over on the Senate. That our arguments have not changed since day one. And yet we're still here in the last policy committee before this goes to the Assembly floor, and these issues have not been resolved.
Right.
So from that, I have a concern as to whether or not we can fix it ultimately before it goes to the Assembly floor.
Well, not necessarily.
Any other questions, comments from committee members? Senator, you may close. If you could be brief, I would appreciate it.
Thank you very much. And I'll just state that, Roe versus Wade wasn't a decision made in court over a law. It was an absence of a law, and that was interpreted as a constitutional protection. We're actually adding detail to a law here. And yes, there will be different cases come through the courts, and the courts will try to interpret the intent of this law in making their decision. And first and foremost, the intent of this law is to prevent discrimination on the basis of goods. And I hope I'm open to working with you, Assemblymember. Thank you for expressing an interest to work with me on this bill. I will work with you on this committee to see if there's any other language that we could provide in here. We've gone through, as the advocate for the chamber has mentioned, we have gone through quite a numerous, extensive amount of meetings on how to provide clarification, on how to prevent frivolous lawsuits, on how to create better definitions, and I'm open to doing more. As long as it doesn't erode the UNRU Act, I'm open to that, and I'll work with this committee and all of you, and I hope that we'll continue to work on this bill, allow it to move forward. Let the people of the state, the victims of discrimination in our state, have their day in court, and this bill will allow them to do that. And I hope I'll have your support today. Thank you, members.
So the motion is do pass as amended. We have a motion. We do not yet have a second.
Mr. Chairman, I will second this motion to support the bill to get out of this committee. And I think we all share the goal of what you were trying to do, Mr. Senator. That being said, we've heard a lot of devils in the details, and I have to say that there have been concerns that have raised that I do very much hope will get resolved, and I trust in the coming weeks there will be discussions around amendments, and I'd like to see them to really feel comfortable before we have a final vote, and I and others are happy to work with you, but at least to keep the conversation going, I will second the motion.
I appreciate it very much. Thank you.
Okay, well, although I will remind the committee, this is our opportunity to look at and work on and fix this bill. If it moves to the floor, can be amended on the floor, this committee is not likely to pull it back unless those amendments substantially change what we've put forward today. So your opportunity, members, to address issues in this bill is based on is now based on your vote today. If we pass it out of this committee, it does go to the floor.
We have a motion and a second. We have how many more weeks before our deadline to get things out of this committee? We have one more hearing still.
We have one more hearing.
I mean, I think a middle ground is to allow staff to try to work with our author for the next week to try to figure out some of these problems and see if there's a compromise before it comes to the floor. Things happen on the floor. We've all amended bills on the floor, including myself. I'm not going to pretend it doesn't happen. But I think the fact that this committee would no longer really have a say, I think that one more week would allow staff to try to work. I think staff is willing to try to find how to address some of the concerns out there. I don't want to put words in their mouth.
Mr. Alejo?
Mr. Chairman, we deliberate this bill extensively, and there seems to be, if there is an area to refine, there is an opportunity to do that on the floor, and it's just regarding the definition, if we're able to get there, about what constitutes a substantially similar or comparable product. It's a very narrow issue. But for us to just push this back and not allow it to go forward when it's just a very narrow issue that we still have an opportunity, and each of us, of the members of this committee, can still weigh in on the floor. If there is concerns, if it hasn't been refined as well as it could, we still have the opportunity to withhold our vote, not vote for it when it gets to the floor. We are all empowered to do that as members of this committee, but I don't see on that narrow issue that why this bill shouldn't move forward today.
And that's up to each of us. Mr. Holden?
Of course.
Yeah, I think that the chair has been very thoughtful in terms of continuing to insert the understanding that it's better. I don't know, maybe I don't want to put words in your mouth, but it's here. It's in this committee. And, I don't want to just say, if it were to be held for a week, that the staff would necessarily be the ones working with the chair. I mean, since I have an issue with trying to hone in on what I think might be a way to help the bill and make it better and be clear on what guidelines could be expanded to, that if we held the bill for a week, I would be willing to work with the author to see if, and whoever else, to see if there's a opportunity to hone it in a little bit better, and I think that would be cleaner.
Okay. So there are some members asking to have another week. What's the pleasure of the author?
I'll work with Assembly Member Holden, absolutely.
Okay.
And the committee.
Okay. There is a motion and a second on the table. Unless there's an amended motion, we do need to address that, unless you're willing to withdraw the motion.
Well, first of all, I'll withdraw my motion as the author is willing to continue work on this bill. But this is such an important bill. It's kind of for me, it's a sad statement that this Judiciary Committee cannot move forward such an important civil rights issue. We're working on technical language, yes. We had the opportunity to do that. But it's so important. And I think it's for me, I just find that unfortunate that we have to hold a bill. For me, it's equivalent that if this committee was considering the Fair Employment and Housing Act, that we said we still have to hold off on doing that for another week because we're stuck on a few words on one definition when we pass legislation all the time. And it's a work in progress. Additional work gets done even when it gets to the floor. We've seen that happen all the time. And somehow we're reluctant to take an important vote here today on this committee, and we have to hold it off for another week to work out a few more words on one provision of the bill. I find that unfortunate, but out of respect for the author and his willingness to keep working with Senator Member Holden, I'm willing to withdraw my motion.
And that is the process. Thank you. So we will hold it over for a week. We will come back, vote only, with an explanation of the amendments. Now, just to be clear, I'm not sure we're going to satisfy all of the opposition at this point. I'm working to satisfy enough members to be able to get votes to pass it out of the committee. That is our goal, and to the floor. So for that item, we will hold it. We will hear this in another week. Have an opportunity to work through those issues and make sure you have your votes.
I appreciate that very much. Thank you.
Thank you. So that brings us now to item number 5. Mr. Leno.